May it please the court. Good morning, Kevin Kono for St. Charles Health System. I'd like to reserve 5 minutes for rebuttal. I'll start with the court's jurisdictional questions. St. Charles does not assert any basis for subject matter jurisdiction other than LMRA preemption. If the district court's analysis were correct, the proper disposition of this case, the proper handling would be for this court to vacate the district court's order and to direct the district court to remand to state court. But the district court always had subject matter jurisdiction under the LMRA because plaintiffs' claims arise under the parties' collective bargaining agreement. Under ORS...
How do we get to that issue? I mean, this has puzzled me because when the district court denied your motion, an attempt was made to appeal, but of course, our court rejected that because there wasn't a final judgment from the district court. And I don't know a way around that problem. Is there any way that you can offer to us that would permit us to review the question you're posing, which is whether federal court should have jurisdiction under 301?
Yes, Your Honor. We're here on what is clearly a reviewable order, an order denying a motion to compel arbitration. The district court didn't remand. It retained the case. Plaintiff made her own strategic decision not to seek to remand the case. So the case proceeded in district court, and we find ourselves here on a reviewable motion that presents the opportunity for this court now to look at the questions underlying the motion to compel arbitration, which from in a certain way overlap with the LMRA preemption question about what the source of these claims are, and for the purposes of the motion to compel arbitration, whether they involve interpretation and application of the collective bargaining agreement.
Well,
I would agree with you that whenever we have jurisdiction, we have to confirm we have Article 3 jurisdiction, including whether the district court held Article 3 jurisdiction, which is a responsibility we have to consider sua sponte at any stage of the litigation. But I think that threshold inquiry about whether we have subject matter jurisdiction is limited to the question of whether the claims are LMRA preempted. I think if we agree with the district court that the claims are not LMRA preempted under our rules of subject matter jurisdiction, then our inquiry must end. We don't reach any of the other issues. Would you agree?
Yeah, I don't disagree, Your Honor, that if the district court's analysis were correct and this court agrees, then again, the proper handling is to end the inquiry there and vacate the district court's order on the motion to compel arbitration, because this court will have concluded that the district court did not have jurisdiction to enter that order. This is much like McRae.
Well, that's not quite right. The district court, like this court, always has jurisdiction to consider its jurisdiction. So what the court should have done is go through the analysis, but the tagline should have been, instead of denying the motion, would have been to remand the case to state court, because there's no federal jurisdiction. But the district court had jurisdiction to decide its jurisdiction.
Yeah, I agree, Your Honor, but the court didn't lead with that tagline and didn't remand, and so now we're here on the motion to compel arbitration, which allows the opportunity for this court to review that analysis under the LMRA.
Correct, but I guess we're sort of saying the same thing. If it's not an LMRA case, then it has to go back to state court.
That is correct, and this
Okay.
court should decide whether it's an LMRA case, and it is.
Okay. Well,
I guess I would just ask you to focus on that and not on whether there was a duty to arbitrate or whether there is an obligation to arbitrate, but you need to focus your argument on the preemption issue. Does that make sense?
Sure.
Okay.
Sure, Your Honor. Thank you for that direction. So this case is an LMRA preemption case because first and foremost, plaintiff's claims arise under the collective bargaining agreement. Under ORS 653261 sub 3, Boley meal and rest period rules do not apply to acute care nurses in a hospital setting working under a collective bargaining agreement. And
So counsel, I think the trouble I see with your preemption argument and what the district court saw is that there's no substantive replacement for the substantive requirement of a continuous meal break, an uninterrupted meal break period. And so there's no affirmative opt-out of that regulatory requirement. So
I don't necessarily agree with that characterization, but in all of the collective bargaining agreement's terms and how the reference to bully rules apply, but in all events, to reach that conclusion requires interpreting the collective bargaining agreement's detailed meal periods. It requires looking at what does it mean to have, for a nurse to have an obligation to take a meal period? What, in the context of this CBA, does it mean for the hospital have an obligation to provide it? And why I was starting with the statute is because that is the starting point. bully rules do not apply.
Well, counsel, suppose the collective bargaining agreement simply said the parties agree that the statutory provisions for meal breaks apply, okay? And so in that case, are we interpreting the collective bargaining agreement or are we interpreting the statute that is incorporated?
You're interpreting the collective bargaining agreement. And first I would step back and say plaintiffs, explain why, but plaintiff's claims here relies on the regulation. It relies on a regulation, and that is the source of this notion of an obligation for an employer to ensure that an employee takes a continuous, uninterrupted meal period. And so
but
in the circumstance—
how's that language just saying we will comply with the law just different from, the provision considered by the Supreme Court in Wright, where they just said, the CBA is just doing what contracts do, which is say we're going to comply with the law. This is just, don't interpret our agreement as overriding legal rights. It's essentially just a statutory right preservation clause.
Right, and you're tying back to Judge Graber's hypothetical?
Yes.
So I think it's important to remember the context here of ORS 653-261 sub 3's exception. This is a narrow exception for acute care nurses in a hospital setting where they have a collective bargaining agreement. And the reason for that exception is because in that unique circumstance, we have patient care with life and death implications. And so the legislature recognized that the nurses in the hospital are best suited to determine how to balance those patient care needs and nurse, meal, and rest break
There's no
periods.
doubt that I agree, right? The state said there can be a collective bargaining opt-out of this requirement. But where in the provision, in the CBA, it seems to me that I read the CBA as saying we're not opting out of the continuous meal break requirement because there's nothing, they don't expressly say we do not have to provide the continuous meal break. They just say, we're going to schedule meal breaks in this way, and otherwise we're going to comply with the law. That seems to be saying we're not opting out of a continuous meal break period.
First of all, it's not an opt-out provision. This is materially different. The Oregon statute says if you prescribe meal and rest period rules, acute care nurse in a hospital setting, in a collective bargaining agreement, then bully rules do not apply.
Well, here's my problem with that. I'm looking at 2 ER 124, it's provision 7.7. The hospital will comply with all legal requirements with respect to meals and breaks if not otherwise provided in this agreement. So they are saying we're not looking to the agreement. If it's not covered, it's not here. We look to state law and federal law to the extent federal law applies.
I'm sorry.
So I guess I don't understand it. Then the only interpretation is is it otherwise provided in the agreement about continuous meal breaks? It is not. There's nothing in there about continuous or discontinuous. And so it seems to me that that takes us to all legal requirements, and that's not a CBA problem, that's a law problem.
Well, first, it is an interpretation, and it is not the only interpretation. Secondly,
What's the other interpretation about complying with all legal requirements if not provided in the agreement?
so one interpretation is when you read Oregon law that says BOLI rules do not apply if you prescribe meal and rest periods, which everyone agrees this does, right? Plaintiff agrees, the district court agreed. This CBA prescribes meal and rest periods. So
This CBA says we'll provide the legally required meal and rest periods in this manner.
that is an interpretation of it. It doesn't literally
Well,
say that.
it's an but then you're taking us to the statute. You say, well, the statute means that this doesn't apply. That's a statutory construction question. That's not a CBA question anymore.
Well, I don't think there's any question of what the statute of 653-261 sub 3 means. It clearly and unambiguously says that BOLI rules do not apply when there are meal and rest periods rules prescribed. So that's a starting point. Secondly, this all other legal provisions can apply. So that takes regulations out of state law. And okay, so if there had not been these two challenge provisions that your honors are referring to, there's no question that BOLI regulations don't apply, right? So that's the starting point. Second, all legal requirements can apply to.
That's because you're interpreting if prescribed by the CBA as mean if they're mentioned by the CBA.
Nothing in the statute says, to the extent not specifically referenced, BOLI regulations do not apply. It is blanket. And I want to save time for rebuttal, but I want to counter one point, the idea that nothing in here says anything about a continuous meal period. Again, that requires interpreting. This collective bargaining agreement refers to one 30-minute meal period. What does that mean? What does that mean in the context of a nurse's obligation to take the meal period? What does it mean when you can have work unit-based specific plans and the content of those? We can't say that there's nothing that addresses this when there's the flexibility that the nurses in the hospital bargain for to decide how to handle meal and rest periods. Respectfully, yeah, thank you.
Thank you, Your Honors. May it please the court.
Can you start with the jurisdictional issue, please? If
Yes.
we agree with the district court that your client's claims are not LMRA preempted, do you agree that the district court lacked subject matter jurisdiction and the case should be remanded?
Yes, we agree with that. But we also would like for the court to consider the interaction between the issues that are raised in the arbitration, or the motion to compel arbitration, and hopefully rule on the merits of that. And
Well,
then remand
if
afterwards.
we affirmed that there is no LMRA preemption, you're agreeing our analysis should end because then there is no more federal court jurisdiction, right? So I think that to the extent the very first issue we have to decide is whether the claims were LMRA preempted. But I think you would advocate for affirming the district court on that conclusion. Is that correct?
That is correct, Your Honor. And again,
Can you respond to your opposing counsel's argument?
Yeah, I have a question about the jurisdictional issue. And that is, looking at 653.261 sub 3. It says, except as provided in another statute, the rules adopted regarding meal periods and rest periods do not apply to nurses who provide acute care in hospital settings if provisions of collective bargaining agreements entered into by the nurses prescribe rules concerning meals and rest periods. Your colleague on the other side reads that as saying, once the collective bargaining agreement prescribes any of its own rules, not the catch-all of we're not going to do it, we'll follow state law. But there are a number of rules provided. Does that mean that none of the regulations apply, or only the ones that are specifically included don't apply? And the second piece of that is, in deciding that, are we interpreting a statute, or are we interpreting the collective bargaining agreement, or both?
So if I can start with the second part first, I think that's easier. Are we if you don't mind, Judge Graber, I believe let's see. In that context, you are interpreting the statute, and
Okay, so what does it mean in your view? Does that mean that if the collective bargaining agreement, such as this one, has a bunch of rules about meals and rest periods, maybe not covering everything that the regulations cover, but covering a whole lot of stuff, as they do here, does that mean that we do not look to the regulations, period?
I think it means, I mean, you have to understand first how the regulation works. And the regulation requires the employer to, or the collective bargaining agreement to prescribe rules. And in the Mazza versus Waterford decision, the court laid out clearly what to prescribe means in the context of laying out meal and rest period rules, describing what BOLI was supposed to do, and that was to prescribe rules. And that meant to dictate to, it was to affirmatively state these rules, not just to defer to the statute, which is what we have here.
But we have some affirmative statements we've got 2 pages of collective bargaining agreement that speak specifically to the meal breaks and rest periods. And the lawsuit you've brought, as I understand it, says for structural reasons, plaintiff and their putative class members never got meal breaks because they had charting responsibilities and they might be notified about an emergency and so forth. And the collective bargaining agreement speaks specifically to things like it being the responsibility of the nurse to take the time. If the nurse anticipates that he or she will not be able to take a break, they notify the supervisor. There's even an explicit provision about the parties agree the provision of rest breaks and meal periods is best addressed by unit-based decisions where the affected nurses and nursing leadership are involved in creative and flexible approaches, none of which appears to be reflected in the complaint that you filed, which argues that we never got a single uninterrupted meal break because we had these other obligations. Is there anything, any evidence, anything in the record or anything in your allegations that suggests that your plaintiff ever gave notice to the supervisor that she anticipated she wouldn't be able to take a meal break?
Your Honor, I don't know that the...
Start with that question. Is there anything that suggests that the supervisor was ever notified that a meal break could not be taken?
No, and the record's not...
So how do we say that the collective bargaining agreement is irrelevant to the claims that you've brought?
We don't say that it's completely irrelevant.
Well, it seems to me that you're trying to say that because of these structural defects, my client and all the other nurses never got meal breaks, even though the collective bargaining agreement says it's their responsibility to take them. If they can't take them, they notify. They work out creative and flexible approaches, none of which appears to be satisfied or covered in the complaint that you've brought and for which you hope to recover complete payment for all meal breaks because you allege that none of them were ever possible. Those seem inconsistent to me.
To be clear, our complaint is only seeking payment for the ones where we can prove a violation. and we have not had discovery, and so there
Well,
may be some.
your client should be the source of when there was a violation because she should be able to identify when I didn't get a meal break. But there's nothing suggesting anything like that. The suggestion is because of structural problems, she never got a meal break. And that seems to me inconsistent with the CBA.
The way that the meal periods rules have been applied throughout this entire period, including when the CBA was enacted or signed by both sides, has required that employers take an active role in monitoring and enforcing the meal periods.
And she's supposed to call it to the attention of the supervisor when she doesn't think she's going to get a meal break. And there's no suggestion that that was ever done.
And the case law provides that that when an employer makes a rule that requires a nurse to give advance notice, to submit corrections, to take the meal period, that does not change the employer's obligation. And so
Well, how about the
essentially,
provision that says it's the nurse's responsibility to take it?
that's a
And if you
provision.
can't take it, you say something about it. And you don't say something about it until you bring a lawsuit years later. That doesn't seem consistent with the CBA to me.
That's exactly the kind of provision that the Maza court said was inadequate to excuse an employer from their responsibility.
But Mazda didn't deal with the conundrum of this carve-out for nurses, correct?
That's correct, Your Honor.
So I'm still stuck on that as to what that actually means. And I'm wondering aloud, I hadn't thought of this until just this moment, so it may be really a foolish question. But it seems to me that we might want to certify a question to the Oregon Supreme Court about the meaning of 653.261 sub 3 as to what it means for if provisions of the collective bargaining agreements prescribe rules. Does that mean any rules, as your colleague suggests? Does it mean that only the ones that are prescribed are not to be followed?
Judge Graber, I don't disagree that would be appropriate, but we think the better approach is to look at the legislative history that requires that these rules, or that shows that the legislative intent was that these rules were to allow the parties to a collective bargaining agreement to improve upon the regulatory scheme.
Well, I don't know if the old case of PGE versus Boley is still alive and well in Oregon interpretation, but legislative history is relevant when there's an ambiguity, and here there is an ambiguity, so I guess it would be relevant. But I thought the legislative history showed, and I may be entirely wrong about this, that it allows for both better and worse, not just improvements, but different.
So, Your Honor, the legislative history is on better footing than in the PGE case versus Boley. It's State versus Gaines, I believe, is the case that allows at the first level of analysis with the text and context to look at the legislative history and weigh that and use that to understand.
Am I wrong about the legislative history, though? That it wasn't just, oh, this is a floor, that the specific history of this section allows differences that could be considered both better or worse or the same but not identical?
Well, if you look at what was discussed was only the possibility that this would allow the parties to expressly agree to better provisions. And what we don't have is any express agreement to what happens when a nurse's meal period is interrupted. And I understand that it's easy to draw your attention away to these other circumstances around it, but nothing whatsoever in the contract addresses what should happen when a nurse's meal period is interrupted, except for this deferral to state law in two instances at section 7.7, kind of in the header, and also in 7.7C, which expressly includes BOLI regulations.
Let me ask for the language from the statute. Is it your position that provisions of the collective bargaining agreement entered into applicable to this hospital prescribe rules concerning meal periods and rest periods? Is that true or not true?
It clearly prescribes some rules that alter the legislative.
But prescribes rules concerning meal periods and rest periods. So by the language of the statute, which doesn't say it has to be better, it can be worse, it just says, if provisions of the CBA prescribe rules concerning meal periods and rest periods, and you acknowledge that, in fact, the CBA here does that, what further question is there?
I think the question is, does that interpretation of the exception violate the National Labor Relations Act by discriminating against union workers? And I think that is something that we raised in our briefing on the Section 301 challenge, and integrated into our briefing on the Federal Arbitration Act issue. And it is something that also came up in the legislative committee when they were talking about how these rules were supposed to allow the employer and the union to bargain for improvements to nurses, not to throw away all of their meal and rest period protections, which are health and safety protections to avoid these nurses who, in this case, we're advocating for a class of nurses who worked through the pandemic. And again, this is just the acute care nurses.
Which is what this statutory provision singles out. Everybody seems to understand that's a unique position, and we've got to figure out ways to relax the requirements that apply to everybody else. And we have a CBA that talks itself about the best way to handle this is to work out creative and flexible arrangements worked out by the people involved, including the nurses.
Counsel, I do want to go back to one thing that Judge Clifton was asking in terms of the nature of your client's claims. My understanding is that you allege that the nurses were able to take a meal break in the sense they were able to start a meal break, and that they would meet their responsibility to take one in sense by starting one. And the problem is that it would be interrupted. Is that correct?
That is one way that it happened. Now, I think it's much worse than that on a lot of levels when we get into the details.
Okay. The other question, I think we keep going in circles about is whether the interpretation of the state law as saying any CBA provision that mentions or provides for any aspect of the provision of meal and rest breaks then means none of the regulations apply, even if they were not specifically replaced by something else? Or is it really, does the statute say essentially only if the CBA prescribes something else, whether better or worse, will they be displaced by the CBA? I think that comes back to Judge Graber's question, if that's a statutory interpretation question. Is that correct?
That is correct, Your Honor. We believe that is a statutory interpretation question, and I did not get a chance to respond to the fact that the Burnside second prong, I think, requires a much stronger ambiguity to be brought up by defendant than this question of whether a meal period was required to be taken or required to be provided. The regulation already requires that the employer provide a meal period, so that there is no alteration there. If you look at the Kramer versus Consolidated Freightways case, alleging a hypothetical connection between the terms and the claims is not enough to raise the kind of ambiguity that requires a collective bargaining agreement be addressed. And I know I'm over my time.
We took you there.
Okay, okay.
You can
And-
wrap
and
up though, please. Yep.
I just really strongly urge the court to take a close look at McCollum versus Roberts, how that came up in the legislative history, and what this kind of absolutist interpretation of what we view as an opt-out
Understand
provision
the argument
will
from the
be
briefing.
addressed.
Thank
Okay,
you.
thank you.
We'll give counsel 3 minutes, Kathy, please.
Thank you, Your Honor. I want to pick up on the Burnside second prong and statutory interpretation questions. The question, what does do not apply mean in ORS 6532613, while our position it's unambiguous, is a question of statutory interpretation, but this court need not reach that because the Burnside second prong says there's LMRA preemption and thus federal court jurisdiction where a claim is substantially dependent on the analysis of the collective bargaining agreement. And so even if there's some question about whether do not apply means no Boley rule applies, which is our position, or it means that only if there is a rule that addresses the specific issue in the CBA does it apply. You still have to analyze the collective bargaining agreement to determine what that means.
Difference between reference and interpretation, right?
Yes.
So we can refer to the collective bargaining agreement to see if it does that. And if we don't, and if it doesn't plainly, then we don't get into an interpretive dispute. Is that correct?
If it merely requires looking to, that's correct, but that's not this case. Here, first of all, I would like to talk about the two references to either legal requirements or Boley regulations within the collective bargaining agreement. In section 7.7, it does refer to the hospital will comply with all legal requirements with respect to meal and breaks, if not otherwise provided in this agreement. So you can't stop there and just say it applies. You have to analyze the terms of the agreement. Section 7.7C says all other provisions in the labor agreement, work instructions, or Boley regulations shall apply. So you have to determine what the CBA says. And our position is there is no way to merely look to these detailed meal period provisions and conclude there is no right addressed relating to a continuous uninterrupted meal period. And it's for the reasons I articulated earlier. This collective bargaining agreement says a nurse is entitled to one 30-minute meal period. There is a question about what does that mean? One interpretation might be that means a continuous uninterrupted meal period, or it might mean something else.
Right, and then we would have to review that in the context of the provision that says this hospital will comply with all legal requirements with respect to meals and breaks if not otherwise provided in this agreement.
Right, so you have to interpret if it's otherwise provided in this agreement.
Well, there's nothing about continuity or discontinuity in the agreement. Would you agree with that?
There's nothing about,
There's no specific statement in the CBA concerning the continuity or discontinuity of a meal or rest break. Would you agree with that?
I agree that those words do not appear in the collective bargaining agreement, but not necessarily that the collective bargaining agreement does not address the concept, because that requires an interpretation of the phrase I just referenced, one 30-minute meal period, right? That's one issue. Another issue that underlies plaintiff's claim, and this gets to some of Judge Clifton's questions, is the idea, well, did the nurse get a meal period and then choose to work during it? The nurse in this collective bargaining agreement has the obligation to take the meal period, and that is materially different than MASA, the Boley regulation, or any interpretation of it. And so now you have to look at what does that mean compared to how plaintiff has brought her claim. That requires looking at her claim and interpreting the requirements of the collective bargaining agreement to determine whether she has a claim under the collective bargaining agreement or whether it's solely a state law right. So even if we have this construction of the statute that says that it's interpreted to mean only if it's specifically addressed, we have this question about what does it mean for the nurse to have the obligation to take the meal period. That requires an analysis of the collective bargaining agreement, and that means that the court has jurisdiction, and it means that those are questions that an arbitrator has to decide under the parties' arbitration agreement.
I think we understand your arguments.
Thank you.
Thank you, counsel. This matter is submitted.
All rise. This court is adjourned until tomorrow morning at 9:30. Thank you.